elections are coming up, so if you are thinking about leadership or if you have questions about FedSoc in general, if you're wondering if you paid your dues maybe, stop by. Alex and I are going to be hosting office hours Monday and Tuesday during the lunch hour, room 487. Come by, ask us anything.
Ask me anything. You mean anything, right?
You mean anything.
Risky.
Anything FedSoc, anything possible, come by, see us. We also have our artificial intelligence, economic abundance or surveillance state debate coming up next week, Wednesday, March 5th. Same time, lunch hour at room 250. And then for our dues paying members, we have our alumni reception, 5th annual, next Thursday. RSVP is required and you have to be a current dues paying member. Justice Montgomery is our guest of honor, so you're not going to want to miss that. The attorneys chapter is doing a First Amendment roundup at Tombstone Brewing. Discounted ticket at the door for students, $10. Grab a drink, listen to recent First Amendment cases. And then e-board elections will happen after spring break, so lots going on. If you're not receiving our newsletter and you would like to, there's going to be a QR code on the screen during the duration of this event. Please scan it, drop your email in there, and we'll get you on the list. And without further ado, I'm going to introduce our speakers. First, we have Professor Blackman.
Hi.
Professor Blackman is a national thought leader on constitutional law and the United States Supreme Court. Josh, his work has been quoted during 2 presidential impeachment
Back to back.
and he has testified before Congress and advises federal and state lawmakers. Josh regularly appears on television, including NBC, CBS, ABC, Fox, and BBC. Josh is a frequent guest on NPR and other syndicated radio programs. He has published commentaries in the New York Times, the Wall Street Journal, the Washington Post, and other national leading publications. Since 2012, Josh has served as a professor at South Texas College of Law, Houston. He holds the Centennial Chair for Constitutional Law. He has also authored 3 books, one of which is a Amazon top 5 bestseller, An Introduction to Constitutional Law. For those of you that are in constitutional law, maybe pick it up. Josh has written more than 7 dozen law review articles that have been cited nearly 1,000 times. He was also selected for Forbes 30 Under 30 in Law and Policy. Josh is the president of the Harlan Institute and founded Fantasy SCOTUS, which is a fantasy league for the Supreme Court docket.
You should all play.
And he has amazing tweets. So if you're on X, follow him, Josh M. Blackman.
Thank you.
We also have Jared Keenan here from the American Civil Liberties Union of Arizona. Josh is the legal director for the ACLU of Arizona, where he oversees the litigation docket and manages a team of 4 staff attorneys focusing on criminal legal reform, education equity, LGBTQ equality, and immigrants' rights, in addition to other core civil liberties. After graduating from Boston University School of Law, Jared worked as a public defender in Boston and also in Mojave and Yavapai counties here in Arizona before joining the ACLU. As a public defender, Jared represented individuals charged with serious felony offenses, including capital murder. He also represented criminal defendants on appeal through special actions, arguing several times before the Arizona Court of Appeals and the Arizona Supreme Court. As the legal director of the ACLU of Arizona, Jared continues to work on criminal law reform in the state through advocacy and litigation, focusing on prisoners' rights, prosecutor transparency and accountability, and reform to Arizona's criminal code and rules. Thank you, Jared, for being here. And then last but certainly not least, we have Justice Andrew Gould. Justice Gould is now a partner at Holtzman Vogel and focuses his practice on appellate commercial litigation and constitutional law. Prior to joining Holtzman Vogel, Justice Gould was a justice of the Arizona Supreme Court from 2016 to 2021. After retiring from the bench, he worked as senior counsel for First Liberty Institute, litigating religious liberty cases throughout the United States. He also has served as a judge on Division I of the Arizona Court of Appeals from 2011 to 2016, where he authored over 400 opinions and served as a judge of the Superior Court in Yuma County for 11 years. So please join me in welcoming our guests.
Okay, let's get started. We're going to start with Jared first in his opening statement, and then Professor Blackman will go second. I just want to generally set the table here. In general, presidential executive orders on immigration are constitutional, provided they adhere to certain statutory and constitutional limits. The President has broad authority under the Immigration and Nationality Act to control the entry of quote-unquote illegal aliens into the United States whenever it is deemed detrimental to the interests of the United States. However, the authority is not absolute. It's been challenged, and it must comply with the statutory requirements and constitutional protections. Also at issue today, and I know both speakers are going to talk about this, is the 14th Amendment, Section 1, that provides, quote, all persons born in the United States are citizens of the United States. So there's been some challenges to that. So that's a very broad brush of the issues today. And Jared, your opening statement.
Thank you. Thanks for having me. Birthright citizenship embodies America's most fundamental promise that all children born on our soil begin life as full and equal members of our national community, regardless of their parents' origins, status, or circumstances. And this tradition of birthright citizenship is supported by history, the plain language of the Constitution, acts of Congress, and Supreme Court precedent. First, birthright citizenship existed, it's important to note or keep in mind that birthright citizenship existed prior to the enactment of the 14th Amendment. There is a long common law tradition of birthright citizenship, and in fact, birthright citizenship has always been our tradition in the United States. You can see birthright citizenship alluded to in Article 2, Section 1 of the Constitution, which says that no person except a natural-born citizen shall be eligible for the office of president. But despite this history, we have the Dred Scott decision, the notorious Dred Scott decision, which created a carve-out or exception for the children and descendants of enslaved African Americans from the enjoyment of birthright citizenship. The framers of the 14th Amendment, however, specifically enshrined the principle of birthright citizenship in our Constitution's text to ensure no one, not even the president, could deny children born in America their rightful place as citizens. And this was done to prevent the type of carve-outs or exceptions to birthright citizens that we saw not only in the Dred Scott decision, but carve-outs for other specific groups of people based on theories of allegiance or protection or what have you. And the adoption of the 14th Amendment was done with full knowledge and intent that it would protect the children of immigrants. Often when people discuss the origins of the 14th Amendment, they do so through the lens of overturning Dred Scott and with only addressing the history of slavery and emancipation in mind. And sometimes there's even like this implication that immigration was not something explicitly thought about at the time of the 14th Amendment, when it was ratified. And while it is certainly true that the 14th Amendment was intended to address slavery, address the history of slavery, when you look at the debates over the Civil Rights Act of 1866 and the 14th Amendment, you see Congress explicitly discussed immigrants, including those immigrants who at that time were the most worrisome to Americans, Chinese immigrants, who because of the 1790 Naturalization Act could not naturalize themselves, but whose children would not be excluded from birthright citizenship. Indeed, when specifically asked whether the citizenship clause of the 14th Amendment would allow the children of Chinese immigrants or the children of what they referred to as gypsies, whether those children would have birthright citizenship, the answer was an emphatic yes from the drafters of the 14th Amendment. And so the citizenship clause of the 14th Amendment provides, as Justice Gould noted, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. In United States versus Wong Kim Ark, the Supreme Court confirmed that children born in the United States to to non-citizen parents are citizens under the 14th Amendment Citizenship Clause. There's also Plyler v. Doe from 1982, which explicitly held that protections of the 14th Amendment extend to anyone, citizen or stranger, who is subject to the laws of the state and reaches into every corner of a state's territory, concluding that undocumented immigrants or those in the United States unlawfully are subject to the full range of obligations imposed by the state's civil and criminal laws. And in INS versus Rios Pineda from 1985, albeit probably in dicta, that case at least acknowledged that a child born in the United States to parents who are undocumented is a U.S. citizen. Furthermore, Congress codified birthright citizenship in 1940 and recodified it in 1952. So for decades, Congress too agreed birthright citizenship applied to the children of undocumented immigrants. So again, our tradition of birthright citizenship, including for the children of undocumented immigrants, is supported by the history, the plain language of the Constitution, acts of Congress, and Supreme Court precedent. Finally, I will close by noting that citizenship stripping is a practice more commonly associated with totalitarian regimes. The Soviet Union stripped millions of their citizenship during Joseph Stalin's rule. Apartheid South Africa revoked the citizenship of the black population in its entirety, amounting to 70% of the residents of the country at that time. And during the 4 years that the Nazi collaborating Vichy government controlled France, 15,000 French citizens, the vast majority of them Jews, lost their citizenship. Regardless of whether the courts ultimately block President Trump's executive order, as they have so far consistently done, real damage will ensue and is already ensuing for immigrant communities in this country, for indigenous communities in this country, and for communities of color throughout the country. And while our nation has rarely lived up to the vision beautifully espoused by Emma Lazarus, which is cast in bronze on the pedestal of the Statue of Liberty, I think it is something we as a nation should strive for. And in her words, "Give me your tired, your poor, your huddled masses yearning to breathe free, the wretched refuse of your teeming shores. Send these, the homeless, tempest-tossed to me. I lift my lamp beside the golden door."
Thank you.
Very good.
Jared?
How do I top Emma Lazarus? Pleasure to be here. Thank you so much. So we actually agree on certain things. I looked into the birthright citizenship issue maybe a decade ago, and I came away persuaded that the best answer, as a matter of original meaning, is that birthright citizenship is provided by the 14th Amendment. But I'm going to give some caveats, and I'll explain why these are important. The first thing to note is that there are different sources of citizenship. In 1866, Congress passed a statute that purported to grant citizenship. And the language in that statute said, if you're born in the United States and you're not subject to any foreign allegiance, right? So there was a statute that said if you're subject to a foreign allegiance, you would not be a citizen. The 14th Amendment does not have that language. So what do we take from this? One argument is, well, when you change the language, that means there's a different meaning, and that our 14th Amendment doesn't turn on allegiances. Another argument is, when you change the language, you're actually embracing that meaning and you're just using different words. I think on balance, the better argument is a different language means a different meaning. It's more broad. Others argue that they didn't try to radically change the concept, they just used more concise language. Okay, that's point number one. Point number two, when we talk about original meaning, we say, what did the words mean? Again, I think Jared's right. The meaning of subject to the jurisdiction in the 14th Amendment means, are you subject to our laws? But it's true that during the debates of the 14th Amendment, people suggested otherwise. So the exchange he mentioned was Senator Edgar Cowan in Pennsylvania. He said, quote, "Is a child of a gypsy born in Pennsylvania a citizen?" Then Senator John Conness of California said, "They shall be citizens." So how do we look at legislative debates? Does one person get to decide what the thing means? Or does it have a broader meaning of how society understands it, right? Justice Scalia is very famous for saying we do not look at legislative history because it's what one person means. So again, even at the time, there's some people who dispute the notion of birthright citizenship. Again, I think on balance, there's more evidence supporting birthright citizenship, but I think it's actually somewhat closer. Point 3, Supreme Court precedent. There's a case that Jared mentioned called United States against Wong Kim Ark. This case has been discussed and read for more than 100 years. But the facts of this case are this. Wong Kim Ark was the child of Chinese immigrants who were here on a permanent lawful status. We now call it basically a green card holder, if we had it today. And the Supreme Court said that yes, he is a birthright citizen. But a key element of that analysis is that his parents were here lawfully. They had permission to be here. Now, you want to talk about holding, you want to talk about dicta, we can argue about that forever. But I don't think, and I say this as someone who supports Jared's position in large part, I don't think Wong Kim Ark settles this issue. I really don't think it does. Plyler versus Doe, it was a Brennan opinion from 1981. That was about equal protection. It was not really about birthright citizenship. At most, that's a dicta. That doesn't get you very far. You have statutes. Congress has enacted several statutes over this last century which pretty much recognize birthright citizenship in Hawaii and other places. So I think Congress probably operates under the presumption that there is birthright citizenship. But again, this is not settled by the Supreme Court. Where does this all leave us? Okay, so President Trump issued his order. First off, it's not retroactive, yet at least. He's not seeking to denaturalize anyone. The order said, after a certain date, the children born here of certain parents will not be citizens. So people who have citizenship, at least for now, you are secure in that citizenship. This order never went into effect, but the order was very broad. It didn't just apply to those who are here illegally, as however you might define it. Even people here on student visas and otherwise have children, their kids would not be birthright citizenship. So again, I think, again, the best reading based on original meaning is that this phrase, subject to the jurisdiction, means are you subject to our laws? But I want to throw a wrinkle into this debate. So the topic, it's not there anymore. The topic here was both birthright citizenship and invasion. So pop quiz. How many clauses of the Constitution reference invasion? Anyone know the number? 1? Is it 2? Is it 3? The answer is 4. Who knew this? I didn't know this until recently. There are 4 clauses of the Constitution that mention invasion. And this may not seem important to you all, but I think it was important to the framers of the Constitution because they were worried about invasions. Right? So there's one provision which you may have studied that says the writ of habeas corpus can be suspended by Congress in case of invasion. Right? So Congress has the power to suspend habeas corpus if they find there's an invasion. That's number 1. Number 2, the president can call forth the militia in case of invasion. What that tells us is the president has the power to decide, okay, there's an invasion. Let me call forth the militia. Number 3, this one you may have heard about, called the guarantee clause. The federal government guarantees to the states a Republican form of government, and they also guarantee the states they'll be protected against invasion. But there's a wrinkle. If the feds fail to protect the states against invasion, clause number 4, the states can take it into their own hands. This, I swear, is in the Constitution. If there is an invasion, if a state's actually being invaded, the state has war powers. The state can literally engage in war to stop an invasion. And what does that mean? When a state is exercising a federal power, Congress cannot control that. Right? The same way that states pick electors, that states can elect senators, and so on. There's certain functions assigned to the states. When there is an invasion, the states have war powers. And if there are any statutes to the contrary, the state's war powers control. I know that's a shocking thought. You're like, oh my God, Josh, how can that possibly be correct, right? How can a state engage in war? It's in the Constitution, right? It's right there in black and white. It's been there for 200-something years. Okay, now, why is this relevant? In 2024, the Texas Attorney General, where I live, declared that there was an invasion of the southern border. And you can describe this in many ways. There are cartels, there are gangs, there are marauders, whatever you want to call it, people engaging in violence at the southern border. But they also said that the flow of migrants constitutes an invasion. Okay, at the time, the Biden administration challenged it. They said, no, there's no invasion, and we, the federal government, have to decide where it is. And the courts agreed. The courts said that whether there's an invasion is a political question for the federal government, the states cannot declare it. That made a lot of sense with Biden in office. That's a political question. But now, Trump's in office. And what did he do on day 1 on January 20th? He declared an invasion of the southern border. So the same judges who said, oh, this is a political question, we can't get involved with this, now have their hands tied, don't they? Now, if the president declares an invasion, and Congress can as well, that's not a filibuster motion, what happens then? It activates war powers by the states, and it gives the president authority to stop and repel the invasion. So far, Trump hasn't actually used these powers in any meaningful sense, but there's an interaction between the invasion clauses and what my friend Jared was talking about, birthright citizenship. This part is actually not in dispute, right? Everyone agrees that if you're the child of a diplomat, you are not a birthright citizen. I think we all agree on that much. That's like the easy example. What if you're the child of an invading army, right? I'll give you an example. It's gross, but bear with me. Mohammed Atta, right? One of the planners of the 9/11 hijackers. He came here to attack the World Trade Center. That was his plan. What if he fathered a child while he was here? He had lawful status. He was here on a visa of some sort. Would this kid be birthright citizenship? I would say not. He's an invader. He came here to destroy our country. Imagine if, let's just say Pearl Harbor turned out differently, right? The Arizona went differently, right? Let's say that Japan occupied Hawaii, and they brought their families there. Would the Japanese occupiers born on U.S. soil have been birthright citizens? I'd say the answer is absolutely not. Again, no one fights me on this point. The point they fight me on is, what is an invasion? Now, there's different ways of reading this word invasion, and I'll give out both sides. I try to always be fair to my students. The Constitution uses the word invasion in a few places, always alongside terms like war, insurrection, domestic violence, things that connote violence, things that connote belligerence. You think of armed hostilities, people bringing guns and weapons and so forth. So there's one argument that the Constitution refers to invasion only in terms of belligerence, right? Hostility. The courts haven't really addressed this. A few courts sort of mentioned in dicta. They said, oh, well, this is a political question, and this only involves the armies and so on. But by virtue of saying it's a political question, that means it's a political branch that gets to decide when there is an invasion. And that, I think, is significant, right? Again, all these opinions saying political question turned on President said there was not an invasion. There's another line of scholarship, Robert Nadelson and Andrew Hyman and others suggest that invasion can be non-hostile in the sense of militant. There's quotes coming back to Benjamin Franklin calling migrants crossing the border to Pennsylvania as an invasion. There's authority here. If you've ever taken property law, adverse possession, right? Invasion of your property rights, it's not always hostile. But I don't mean to say this is a slam dunk. In fact, guys, I don't have to say it's a slam dunk. I think the political branches get to decide when there's a war, when there's an invasion, when there's an insurrection. I don't think courts should be second guessing that. And if I'm right about that, that has significant implications. Because if you're the child of an invader, however defined, you are not a birthright citizen. So I think without question, Trump's order is unquestionably broad. If you're here on a visa, you're a birthright citizen. That's an easy question for me. The harder one is that the children of invaders, whoever those are, do they get birthright citizenship? And that's, I know, an unpleasant thought. It's unpleasant to think of people as invaders. It's not a nice thing to think about. But there's a lot of law here that's very much open-ended, right? I want to talk now briefly about suspension clause, the third of the triad. Do you guys still learn the Guantanamo cases in con law? Do you even teach those anymore? This was a big deal 20 years ago when we were in law school, right? This was a big deal because President George W. Bush decided to transfer people seized in Afghanistan to Guantanamo Bay, Cuba. Now, he didn't do this because that's ocean breeze, right? That's not why he sent them there. He sent them there because he had to be beyond the jurisdiction of the federal courts. The idea is, well, the habeas corpus provision applies to the U.S. soil. And if we want to detain these people indefinitely in these facilities like Gitmo, we don't have to subject to federal court jurisdiction. That didn't work. There were a series of cases. So first the court said, you can't do this because Congress didn't approve it. So then Congress passes a statute authorizing the detention of these aliens in Guantanamo. Then the Supreme Court says, never mind, that's unconstitutional. And then we get a case called Boumediene in 2008, Justice Kennedy opinion, where it said that the writ of habeas corpus flows to Guantanamo Bay, even though it's not under what they call the territorial sovereignty of the United States. It's basically within our government, close enough. After that, we kind of forgot about Guantanamo, right? The people were still there. President Obama tried holding a trial. There was a political backlash. They're still there. There's about 36 people still in the Guantanamo facility. But shortly after President Trump came to office, he said, aha, I know. He started sending these Venezuelan gang members down to Gitmo, right? That was not on my bingo card, but that's what happened. He since moved them back and forth, but we don't really know. The ACLU, I think, is involved in litigation challenging their detention at Guantanamo Bay, arguing it violates the suspension clause, that Congress hasn't suspended it. But again, if there's an invasion, can you move the invaders down to Guantanamo as part of your war powers? Right? These are not issues that are clear-cut, but you'll see the invasion clause affects so many aspects of our current debates. Last point on the suspension clause. in the United States, there's a law on the books that says if you're apprehended within a certain number of miles of the border, you can basically be detained and summarily removed. Presidents have said it's within a certain small distance. Trump has said the entire United States is subject to this law. That if you're detained anywhere in the United States and you've entered illegally, we can remove you summarily. That's a plausible reading of the statute, I think. But if so, it might raise suspension clause concerns because you're basically in the United States, you have ties here, you're giving almost no process for removal. So, again, invasion may seem sort of remote and unnecessary, but it touches so many things of what's going on with the immigration situation now. I think the Supreme Court will have to eventually get to it sooner or later. I'm done. Thank you so much for your attention.
Rebuttal?
Thank you. Yeah, I have a couple responses specifically on the question of invasion. So I think first it's important to know that there are, I think uncontroversially, three historical exceptions to birthright citizenship. Obviously, children of diplomats is like the paradigmatic example. The diplomats themselves, they're physically present in the United States, but they remain subject and are here actually to represent another sovereign, right? And so historically, traditionally, the children of diplomats did not benefit from birthright citizenship. And then there's this sort of specific one in the US context that relates to Native Americans who are exercising sovereignty of their own and are not birthright citizens, which is a recognition that they are actually, that they are in fact citizens of their own nation. But under the Indian Citizenship Act, I believe 1924, all Native Americans born in the United States are also US citizens. And it's the second one, though, that I think I'd like to discuss a little bit briefly. So traditionally, right, and by the way, this comes from the English common law, that children born of foreign armies, and this was also articulated in the Wong Kim Ark case, that children born of foreign armies living in U.S. territory that those armies had conquered are excluded from birthright citizenship. I think one thing I think I would like to look into a bit further is just practically speaking, that makes sense that they wouldn't necessarily be an invading army, right? They would have to be some sort of conquering army because otherwise it'd be very unlikely, at least historically, that anyone pregnant would be involved in the invasion. And so it in the articulation of the Supreme Court in the case I mentioned, right, this has to do with armies that have actually conquered a portion of the United States and are holding it, and children are born in those areas. That is a slightly different, or maybe a significant difference between that and an actively invading army. And then the other piece about sort of migrants or immigrants generally constituting an invasion, I think when we think about it for birthright citizenship purposes, a couple things. First, even if you sort of are sympathetic to the view that migrants could constitute an invasion, those migrants would still not be occupying any territory within the United States. I mean, I suppose you could argue that they're physically occupying, at least the physical space that they're in, because no other, just physics, they have to be physically present in the U.S. But I don't really think that gets to sort of what the that exception is trying to prevent. And moreover, though, there are a number of international agreements as well as federal law that allows many of these folks to come here legally and seek either refugee status or asylum status in the United States. There's a 1951 convention related to the status of refugees. There's a 1967 protocol to that convention. The 1948 Universal Declaration of Human Rights has some discussion about who can seek asylum and the right to seek asylum. And then obviously the U.S. Refugee Act of 1980. And what those things do, in my view, is allow many of the folks who are seeking to enter this country without documentation a lawful way to do so. And in fact, there are folks who are plaintiffs in some of the challenges against President Trump's executive order who are in this position, right? There is one couple, husband and wife, who are here. Their asylum application is pending, and the wife is in her 3rd trimester. They are expecting a baby in soon, and that baby would normally be a citizen, but for Trump's executive order, which calls that into question. And so again, I think I don't think it's really quibbling with terms. I think it's really looking at the actual exception, the traditional exception to this, to who is granted birthright citizenship and who isn't. And I think the answer is that migrants or undocumented immigrants simply do not qualify as an invasion or an invading army or a conquering army for those purposes. I'll stop there.
Very
Last
good.
word?
Sure. So if we have an originalist debate, I probably agree with Jared, but this is a debate in which the courts have said it's for political branches to decide. I think that is significant. Another related point is there are many countries in the world, mostly in Europe, that do not have birthright citizenship. They actually have fairly arcane and complicated laws with how a child's born. I wonder if this is put to a referendum today. The 20th Amendment, right? Would you repeal birthright citizenship? In fact, one of my sinking feelings, Trump is always usually half a step ahead of me, usually it's half a step. I wonder if he knows he's going to lose this case and he'll use it as an impetus to amend the Constitution and get rid of birthright citizenship. I think it's an 80-20 issue. I think it might actually clear the threshold for an amendment, but maybe I'm wrong. But in our current order, though, he doesn't have to actually win everything. I think even if the court says that the children of invaders are not birthright citizens, that then kicks it off to perhaps a subset of the people crossing the border. So, perhaps, a husband and a wife cross the border who are pregnant and they're here to seek a better life. Maybe that's not invasion, but there are people who come here for ill will, and maybe they're not. I think that itself would, be a significant change in where the law is, or at least a clarification. That's all I got.
Thank you. Questions? Yes.
Professor Blackman, you mentioned the subject to jurisdiction thereof clause.
Mm-hmm.
And I think you said it means that you're subject to our laws. And I'm kind of curious where the line would be drawn there, because it seems like it would get circular if you say, somebody crosses the border illegally, and you say, you broke our laws
Yeah.
detaining you. How are they not subject to the laws once that happens?
Right, it's a good question. You couldn't hear it. So this phrase in the Constitution is subject to the jurisdiction thereof. And that would, I think, mean you're subject to our laws. And he says, well, how do you say you're subject to our laws if you come here and you break the laws and you cross the border, you hop a fence, you do something, and you're illegally? I think the answer is, if they come here illegally, they are subject to our laws, and we can arrest them, detain them, and remove them. A person who's not subject to our laws could not be arrested and detained. So again, when you are an invading army, to use an example, make it easier, right? You're Japan, World War II, and you come here and you're detained, you're held as a prisoner of war. You're not put in a civilian prison, right? There's different treatment of invading armies who are not subject to our jurisdiction. Whereas if you're here and you cross the border, you jump over a fence or something, right? You are subject to our laws. We arrest you, put you in our court system, detain you as well. So I think they are. The harder issue is whether this phrase subject to jurisdiction embodies some sense of loyalty. Now, we allow dual citizenship in this country. Anyone ever take the oath of naturalization here? Curious. If you actually read, yes, so you took the oath. Do you remember the part of the oath where it said you abjure all foreign allegiances? Remember that line? But we allow dual citizenship, don't we? Did you notice that, or?
Yeah.
It's a weird thing, right? So I clerk. Everyone who's going to clerk? When you clerk, the best thing is a naturalization ceremony. It's awesome. It's a lot of fun. People are so happy. But there's this one line that always bothered me. It said, I abjure all foreign allegiances, right? Which means I give up all foreign oaths to citizenship. But we expressly allow dual citizenship, 3 citizenship, 4 citizenship. So it's not clear to me that we're even following our own Constitution. In other words, if we mean it that you're not subject to a foreign allegiance, why we allow dual citizenship? I don't know. It's just sort of this vestige. In fact, if you go to the State Department website, they actually say, oh, we don't really mean this line, right? You basically swearing an oath, oh, you don't actually have to mean this. They actually say this in the explanatory guidance, which I think oaths are important. I don't know if you guys agree. And if you take an oath, I think you mean it. But it also says that I'm sure you read this part, you promise to bear arms in support of the country. Remember that line? Yeah, well, not everyone's subject to the Militia Act. So again, it's a weird, anyway, I'm done. Thank you for the question.
Yeah, no, I think this is why there are these sort of very discrete exceptions traditional and historical exceptions to who can have birthright citizenship, right? And none of them, in my view, apply to folks who come over here undocumented and have a child. Like that child would benefit from birthright citizenship specifically because they are subject to our laws. The Supreme Court has recognized this in a number of cases. I think it's the Platelet case I mentioned earlier. But anyway, so yeah, I agree. There is one thing that I wanted to mention or respond to from Professor Blackman, who discussed, putting this to a vote, and maybe the voters of America would vote to get rid of birthright citizenship, and that may be true. I believe I saw a recent poll, however, that showed that there's a majority of Americans, or maybe not majority, but a higher percentage of Americans who oppose this executive order as supported. But regardless, I think it is a good thing that it's very difficult to amend the U.S. Constitution. A few years ago, I was reading, I believe it was Radley Balco, who is a libertarian journalist, and he was discussing these surveys that Americans did, and they asked them questions about the Bill of Rights, right? The rights enumerated in the Bill of Rights, and large majorities of the public would get rid of these rights if they were put to a vote. And so I think regardless of what the American voter may or may not want to do regarding birthright citizenship, it's in the Constitution, it's clearly there, and we can't just do away with it because of an executive order.
Other questions? Yes.
So I guess this is kind of for both of you. My undergraduate degree was in international security and international law. And so I'm kind of wondering why the invasion clauses aren't referencing a customary international law definition of invasion, especially when given Article 4, Section 4 distinguishes between actual invasions and simple domestic violence that occurs. That Section 4 seems to me to kind of differentiate between something that is an actual invasion by a sovereign power across your borders, with an organized army, etc., versus simple domestic violence, like you have, maybe an internal uprising or gang violence, something like that. That seems to be much more akin to maybe current characterizations of the southern border, rather than a sovereign invading army that under international law would definitely be considered an invasion. So I'm just wondering how you kind of view that distinction.
Yeah,
Professor, start with you.
Yeah, thank you. Very good question. So this concept of customary international law is, as I'm sure my friend would attest, not black and white. There's shades of gray in a lot of this stuff. And what I think some scholars are doing now is looking at how this word invasion was used in the 18th century. And whatever invasion is under law today, customary law today, might be different than it was 200 years ago. I think there is some evidence at the time the Constitution was framed, people used the term invasion to mean someone adverse to right, not necessarily hostile. You're right. I think the fact that it's juxtaposed with domestic violence and so on suggests one answer, but I don't think it's entirely clear-cut. I don't think there's a 100% issue. And if you couple that with the sort of political question angle, again, I think the courts get into a little bit of, what's a war, right? What is it good for? Absolutely not right. When you look at the definition of a war, that is very context-specific. And I think we've had undeclared wars in this country for about 200 years. And things I think should have been declared were not declared. But the courts have said consistently, it's not for us to decide what a war is. And if the courts don't get to decide what a war is, I know that invasion is much different. Because we know what a war is. That's a very clear, say, belligerence between two nations, right? There's no ambiguity about that. We've had a lot of belligerence that's not been declared. So hopefully I answered your question a little bit.
Sure.
I don't really have much to add to that. Yeah, I don't see how under any sort of definition of an invasion you end up saying that what is occurring on the southern border qualifies as an invasion. Right. Although there are certainly probably several votes on the U.S. Supreme Court that will jump on to sort of whatever President Trump wants to do in this arena. But again, I had a hard time finding that.
Yes.
On this topic of invasion, this is a question for both of you. Let's say that there was an organized group, an organized gang, let's say, that came across the border for purposes of engaging in violence, say, in the Colorado suburbs,
Just hypothetically, right?
Hypothetically, would that be more akin to the definition historically of invasion that you talked about earlier?
I still don't see how that would be, because again, I think the key distinction or the key thing that sort of, other than setting aside the example of the Native American example, which is a very specific U.S. issue, but the other two sort of exceptions to birthright citizenship, they both, the sort of key thing that ties them together or makes them similar is this allegiance to another sovereign or another nation. And a criminal gang, from what you're describing, right? A criminal gang entering the United States to commit crimes would be state crimes in Colorado. I don't see that they would be considered an invasion and therefore allow the suspension of birthright citizenship.
Professor?
Yeah, I don't know. I have too much to add to what I've said before. I think, again, the federal government has extensive powers to deal with crime in the United States, right? If there's a gang operating in Colorado, you don't need war powers to deal with a gang in Colorado. But when you're dealing with the southern border in particular, I'll just give Texas as an example, right? Governor of Texas put these buoys, these almost like barrels, these huge floating structures in the Rio Grande River by the southern tip by Eagles Pass. And this was designed to basically discourage people from trying to cross this body of water. The feds came in and said, oh, this is a navigable water, and you're basically violating federal environmental law. I don't think it's actually navigable water. No one can actually put a boat in there, but that's a different story. But when you're dealing with this sort of war power, you get to do stuff you can't do otherwise. So the only reason this argument matters is where the president otherwise lacks the power to do what he wants to do. The feds can indict gang members in Colorado in 5 seconds. That's not you don't need the invasion clause to get there. But to the extent that you want to deal with birthright citizenship, you want to deal with overriding statutory law, that's where the invasion clause comes in. And I agree it should be done carefully. I make no predictions in the Supreme Court, by the way. I have a very bad track record with the Supreme Court. I lose all the time. They reject my stuff all the time, but I never let it persist.
Yes.
Yeah, so I think this is really for both of you, but mostly for Joss. I think I agree with you, Joss, that it's a political question of whether it's invasion or not. I don't think courts would be like, well, if 2 soldiers go over the line, like it's an invasion or not, it's a war. It's probably up to those political branches. I think that where I disagree with you on is how strong the argument is for this invasion that the invasion argument applies to children. So I would get it if, like, the person who's doing the invading, I would understand that. But the child is still subject to the jurisdiction. Like, our Constitution isn't the common law of England. It's written, like, it's written, and it says if you're under the jurisdiction thereof. And so, if the child's if the child grows up, and the invasion, lasts, say, 20 years, and they commit a crime in the U.S., they'd be subject to the criminal jurisdiction of the U.S. That doesn't apply to diplomats, because their entire family gets diplomatic immunity. So I'm wondering, what's your...
Sure, yeah, let me address this twofold. So, imagine again, imagine Pearl Harbor turned out differently, and the Japanese occupied Hawaii, and lived there for an extended period. And let's say they brought their families there, and a woman gave birth. I think that child would not be a citizen. I'm actually pretty confident upon that one. But let me twist my hypothetical before. Muhammad Atta, right, who planned the 9/11 hijacking. Let's say he had a child with a U.S. citizen. He's clearly an invader. Mom's not. She knew nothing of the attacks. What happens to that kid? Let me give you another one. A diplomat has an affair in the United States and sleeps with an American woman and has a child. I'm serious. I've actually looked. I don't know the answer to this question. Is the child of that diplomat's affair a U.S. citizen by birth? Jared, do you have any? I've looked. No one knows the answer to this question. I assume diplomats aren't always faithful. I'm sure it's happened somewhere, right? They're here for a reason, right? And they meet someone, it happens. Is that anyway? So, I'm with you. I think there's a lot of sort of uncertainties here that I just don't have answers to. That's all I can say. But thank you for the question, sir.
Anyone else? Yes.
So actually, I have a question for Professor Blackman. So, under your definition of invasion, it's a purely political question, and courts have no role. Could the president, hypothetically, say, oh, anyone who votes Democrat
Is an invader?
is an invading
Yeah.
army,
Got it.
occupied by people?
Yeah, Occupy Berkeley, right? Literally. Yeah, no, it's a good question. So when I say I think it's a political question, I think that's how the courts have to approach it. I think, though, as an originalist, I can have an opinion as well. We're starting to get into the, will the president start locking up his opponents? Once we get to that point, I think the text of the Constitution doesn't matter too much. You'll find a clause somewhere. It doesn't have to be an invasion clause. I think there are still checks, even with Trump, yes, I believe it, there are still checks in the president's power. But if you actually get to the point where you start locking up your political opponents, at that point, partisan barriers as masses that don't matter very much. You don't need the invasion clause. You have lots of other mechanisms to do it. What if President Trump starts indicting his leading opponent for the presidential election? What happens then? Jack Smith? I don't know. It happens. And then, look what happened in Romania. They just arrested the leading guy who tried to win the election, right? This stuff happens. I didn't answer your question, but I think I did.
I think this isn't going to answer your question either, but one thing I kind of think is interesting about like the proponents of, or the supporters or whatever of President Trump's executive order, the focus is on, or the justification for why the children of certain people do not benefit from birthright citizenship is focusing on the actions of the parents. And one thing that's, I think, very clear about the tradition of birthright citizenship is that it has nothing to do with bloodlines and stuff like that. It has to do with, which, some countries have, like countries in Europe, Germany. But like, it has to do with physically where the child is born, right? And that sort of gets lost when the EO is focusing on the arguably illegal behavior of the parents. And it gets even more attenuated because my understanding is the EO also would strip birthright citizenship of the children of people who are here lawfully on
Correct.
like a temporary student visa
Correct.
or something. And so the justification that, because the parents have done something unlawful, entering the country without proper documentation, right? That doesn't translate over to people who are here lawfully, but on a temporary basis. And so, I think that, my takeaway of it is more that racism is playing a role in this decision, and not sort of some kind of desire to protect the country from an invasion. But either way, it's definitely a contradiction there.
Any more questions? Okay, apparently there are not, but both these very fine speakers are here to take questions as long as for the next 10 minutes.
Thank
So,
you very much.
Thank you.
Thank you.